Good evening. I'm attorney Catherine Henry of Restore Freedom Initiative. Just wanted to go live tonight to give you a quick update. Yes, anything less than an hour and a half is considered a quick update from me, so I guarantee you it'll be less than that. The caption of this post on Facebook Live here was boring court stuff, but good news. So to hold true to that, I'm going to start with the boring court stuff. Last week, a week ago today, I filed a motion and a brief with the Michigan Supreme Court on, sorry, my husband's talking to himself. Are you done? I filed a motion with the Michigan Supreme Court on a new case. This case was not a brand new filing with the Michigan Supreme Court, but this is the one, in case you didn't see any of my prior videos on this, where a case was actually filed with some various doctor's offices and one patient, and they filed a lawsuit against the governor in the U.S. District Court, so trial court at the federal court level. So U.S. District Court in the Western District of Michigan, Southern Division. And basically what the trial court judge in that case said was, we can't decide anything at the trial court level here for federal court because there's some really important issues of state court law that need to be addressed first, and the state Supreme Court of Michigan has never decided these particular issues. So they did what a process called certifying questions. So they certified 2 questions and sent them back down to the state Supreme Court, or Michigan Supreme Court, and asked them to decide those 2 questions. So the 2 questions are whether the 1945 Act, the EPGA, or the 1976 Act, the EMA, whether under either of those the governor has authority after April 30th to issue or renew any executive orders related to the COVID-19 pandemic. The second question was whether the EPGA and or the EMA, so the 1976 or the 1945 statutes, whether they violate the separation of powers and or the non-delegation clauses of the Michigan Constitution. So, of course, my answer to the first question is no, absolutely not. Does she have the ability, even under the EPGA and the EMA, to draft these executive orders related to the COVID-19 pandemic after April 30th? And my answer to question number 2 was, of course, yes, it violates, both of those statutes violate the separation of powers and the non-delegation doctrine, or the non-delegation clause, of the Michigan Constitution. So who am I to this case, though? Because I don't represent the governor, clearly, and I don't represent these doctor's offices or this patient who was denied his, I believe it was a knee surgery because of the COVID-19 executive orders Whitmer has issued. I'm the unofficial attorney of the people of Michigan. I literally filed the brief and the motion as an attorney to represent the interests of the people of the state of Michigan. So, more boring part. From the motion, this is all available on our website, restorefreedommi.com. RestoreFreedomKH.com is going to be its official URL, I guess would be the right way to say that. But at any rate, whether you go there, either way, it should work, and you should be able to get there with, I want to say it's the Resources tab. Is that right, hon? Is it called Resources? And then Documents. And so you'll be able to see the motion that I filed with the brief, with all the attachments. So, let's see here. So just kind of a couple of key things to pull out of here, and it's going to be weird because I'm talking in third person in this, but that's the nature of the beast here. So while Attorney Catherine Henry generally agrees with the position stated by the plaintiffs, in this case, the doctors and that one patient, several key relevant legal points have not yet been placed in front of the court. And being an officer of the court and having sworn an oath to support the U.S. and Michigan constitutions, Catherine Henry has a duty to bring these legal matters to the attention of this court, the Michigan Supreme Court. Given the unique nature of the legal backdrop of this case and the coinciding case brought by the legislature against the governor, the voice of the people remains largely unheard. Attorney Catherine Henry has been communicating daily with thousands of Michiganders for the last 4 months, explaining the legal aspects of what is happening in our state and answering questions for Michiganders in this uncertain time. Therefore, she is uniquely positioned to provide a voice for the people of the state of Michigan and requests oral argument pursuant to MCR 7.312H5. I'm going to pause and say that it's exceedingly rare that you ever, as an amicus, as essentially a friend of the court, not the custody friend of the court kind, but that's what amicus is, a friend of the court, someone who is trying to offer the court an additional set of facts or additional legal argument that can help the court resolve the issue at hand. And I'm not a party to the case. So it is exceedingly rare that an amicus would be granted any kind of oral argument time. But I did request that under the court rule. And so that's what that part was talking about. So in addition to bolster that argument, if you will, I said, Attorney Catherine Henry has been listening and or watching the oral argument presentations in the various cases generally involving the same parties and the same issues. Oral argument is certainly no easy task, and the attorneys of record have done a great job in representing their clients' interests. However, given how these attorneys are confined to the arguments beneficial to that particular client, there are several key legal arguments that have evaded proper oral argument dedication. So, and next point, I just said that neither party is objecting as far as I'm aware, and I was not able to reach the governor's office or the attorneys for the governor by phone, but I was able to reach the plaintiff's attorneys, and they did concur with the filing of this motion. So I said that I therefore respectfully request the court grant this motion and accept for filing my proposed amicus brief. That I also, recognizing the limited circumstances in which oral argument is permitted for an amicus curiae, under MCR, that's Michigan Court Rule 7.312H5, I also request the court to allow me time for oral argument in the matter to allow a full exploration of all issues relevant to resolving these legal matters that directly impact the 10 million people in Michigan. So this is what I submitted to the Supreme Court of Michigan last week on Wednesday. And so that is the motion that went along with the brief that I've talked about in a variety of ways. It is, if you're looking for it, the brief, the underlying brief is in defense of the U.S. Constitution, the Michigan Constitution, and the rights of all citizens. So, like I said, I'm essentially positioning myself as the unofficial attorney for the people of the state of Michigan. So with that being said, I had received an email earlier today and didn't have a chance to look at it until just a moment ago. And so the official Supreme Court filing number, if you are interested in knowing that, is 161492, and the U.S. District Court for the Western District of Michigan court filing number is 120CV414. So this is in re certified questions from the United States District Court, Western District of Michigan, Southern Division. The named parties are actually Midwest Institute of Health, doing business as Grand Health Partners, Wellston Medical Center, Primary Health Services, and Jeffrey Gulick, I believe is how you'd pronounce his name. The listed defendants or named defendants are the governor of the state of Michigan, the Michigan Attorney General, the Michigan Department of Health and Human Services Director as well. So, because he's issued quite a few, or more than enough, I'll just say, emergency orders as the director of the Department of Health and Human Services. So that's a whole nother post for a whole nother day. So this is the language of the order itself, and the text of this is available in the link that I posted with this Facebook Live video. So on the order of the Chief Justice of the Michigan Supreme Court, the separate motions of number one, the I'm not going to pronounce that right. There's another amicus brief that was submitted before mine. Theirs was number one. I'm listed as number two, Catherine Henry. And number three, the House Democratic House Leader and the House Democratic Caucus. All of those three briefs, those motions, to file briefs amicus curiae are granted. So good news is that my brief was allowed to essentially come on, officially come on record in that case. And that's the first filing I've done in that case. The other ones that I've talked about are mostly in the legislature's lawsuit against the governor. The amicus briefs submitted by those entities are accepted for filing. On further order of the Chief Justice, the motion of amicus Catherine Henry for separate oral argument time is granted. Counsel for the parties and amicus are allotted the following oral argument times at the court's special session on September 2nd, 2020. The counsel for plaintiffs will get 30 minutes. The counsel for the governor and the Department of Health and Human Services director will get 20 minutes. Counsel for the Attorney General will get 20 minutes. And amicus Catherine Henry will get 5 minutes. If you can't tell, I'm really excited. Now we just got to figure out a way for me to get the best argument jam-packed into 5 minutes. For those of you who watch my videos on a regular basis, your jaw just dropped and hit the floor, or you started laughing out loud hysterically. But in any event, I have been granted as the only amicus to get oral argument time in this case. And many of you might be aware, or maybe even forgot, that in the Michigan Supreme Court, I was the only one that got an amicus brief accepted in the legislature's lawsuit against the governor at the Michigan Supreme Court level. And at the Court of Appeals level, there are other briefs that were also accepted in addition to my filing at that level. But at the Michigan Supreme Court level, mine was the only brief that was submitted in time and accepted. However, no oral argument was heard on that case so far at the Michigan Supreme Court level. Oral argument was heard last Tuesday at the Court of Appeals level, but no amicus parties were permitted to participate in oral argument. So I have had briefs submitted to the Michigan Supreme Court and the Court of Appeals that basically have been going around and talking about these issues from a variety of very related aspects. So it was very interesting to me when the U.S. District Court certified these two precise questions that, again, I've been already dealing with in a variety of very related ways in different briefs. So I'm very excited that on behalf of the people of the state of Michigan that are fighting to restore freedom, I have been allotted the 5 minutes to argue these points in front of the Michigan Supreme Court. And it's just a very exciting time for me, and I hope it's a very exciting time for you. I take this as very good news that my brief was accepted and that I was granted oral argument time. So it will literally be the plaintiff's attorneys, the governor and the Health and Human Services director, and then the attorney general, and then myself. And those are the only parties or attorneys permitted for oral argument on September 2nd. Don't have the time yet. I'm assuming it'll probably be by Zoom, although it would be fantastic if that could be the first oral argument heard by the Supreme Court in person after COVID-19 began here in Michigan. So in either event, I do believe they have that oral argument available on YouTube. I think they have their own YouTube channel. I believe you can watch it simultaneously. But I wanted to at least let you all know. I think that's all I needed to update you about. So let me just see if there's any questions. I'll have to make it rhyme and become a rapper. Maybe Eminem will give me some pointers, because Michigan's his state too. No questions yet. Awesome. Hey Lori, just so you know, you commented as Restore Freedom, and it looks like I'm commenting to myself that I love myself. So I love you too. Okay. Well, Frank, hopefully I just answered that for you. This case is not the legislature's lawsuit against the governor. It is a group of medical providers and one patient who was denied surgery during this time. They came together as plaintiffs and sued the governor, the attorney general, and the Michigan director of the Department of Health and Human Services. So that's the case. It was a case in federal court that just two particular issues got certified as questions to be dealt with specifically and directly by the Michigan Supreme Court, and that oral argument day is scheduled for September 2nd, 2020. Okay, I don't see any questions. Can you? You can certainly get my autograph. I don't think I'm that special. Lori, you cracked me up. Would all executive orders go away? In theory, if the Supreme Court rules in the manner in which I'm going to argue that they should rule, then yes, all of the executive orders in 2020 that have been based upon emergency powers would go away. It wouldn't matter if she's claiming it's based on the 1976 statute or the 1945 statute. If the Supreme Court, that's a big if the Supreme Court were to go along with or agree with the position I will be arguing that they take, then that is what would happen, because all of those arguments, or excuse me, all of those executive orders are in fact unconstitutional. They're illegal, but they're also blatantly unconstitutional. What are the possible or likely outcome of your oral arguments? Hopefully that answering the last one just answered that, but that is in essence my argument. My argument is that it is completely unconstitutional that these executive orders are being issued. Let's see. I'm trying to figure out if there's a good piece of some of the things I'm arguing in here. I'm on the point of liberties. What liberties are being infringed? And I state that despite the guarantees to equal protection in the U.S. Constitution, our 14th Amendment in the U.S. Constitution, and our state constitution, Article 1, Section 2, similarly situated individuals have been treated differently, right? So we have comic book stores that regularly sell snacks could not be open under some of these executive orders, but liquor stores that, quote, might sell protein bars were allowed to stay open. We also have Article 1, Section 3 in our state constitution that guarantees us the right to peaceably assemble, consult for the common good, instruct our representatives, and petition the government for a redress of grievances, along with, of course, our U.S. Constitution First Amendment right to peaceably assemble and to petition the government for redress of grievances. But, of course, nearly every executive order in 2020 is geared toward keeping people locked in their homes or forcing them to social distance from each other, making it a crime to gather in groups of more than that particular allowed amount, whatever phase or region she has us classified in at the moment. So our liberty to worship God according to the dictates of our own conscience is protected under our state constitution, Article 1, Section 4, of course, along with our U.S. Constitution in the Free Exercise of Religion Clause. But the governor has required masks to be worn and social distancing to be used in such worship activities. Our state constitution, Article 1, Section 5, guarantees that every person may freely speak, write, express, and publish his views on all subjects, where no law shall be enacted to restrain or abridge the liberty of speech or of the press. But gatherings have been prohibited. Press and the public have been limited at the governor's press conferences due to social distancing. And Michiganders are punished with harsher executive order provisions when we gather for speeches at public rallies. Although violent protests where, we're breaking business windows or burning down buildings or things like that, that's totally okay. That doesn't spread COVID. But when we gather peaceably for speeches at the steps of the Capitol, then we're punished with harsher executive order provisions. Article 1, Section 10 protects our right to make contracts unimpaired. Yet these executive orders are literally directly prohibiting thousands of businesses across the state of Michigan from opening, thus directly impairing their ability to perform under their multitudes of contracts that they have. We are guaranteed the right to be secure from unreasonable searches and seizures under the Fourth Amendment to the U.S. Constitution and the state constitution, Article 1, Section 11. Yet the newest executive orders require businesses to utilize contact tracing measures, asking customers and employees about their travels and health history, and taking their temperature, all without being charged a crime or having a warrant even issued. We are all guaranteed due process of law, of course, in the 5th and 14th Amendments of the U.S. Constitution, as well as Article 1, Section 17 of our state constitution. Yet all of these new restrictions upon us as individuals and business owners are being imposed without adherence to any of our constitutionally required processes for creating and enforcing laws, the whole series of which I fully explain in the brief. Further, the licensing agencies of the state are revoking licenses summarily, right, without due process, taking away these licenses from individuals and businesses for non-compliance with the executive orders without any kind of direct judicial oversight or fair treatment in the investigation or prosecution of these offenses. And although the EPGA and the EMA, the 1945 and 1976 statutes, and the individual executive orders make it a misdemeanor, punishable by a fine for some of them, and jail time and a fine for others, to violate these executive orders, additional civil monetary citations are being issued for the same violations. That's in those emergency orders issued by the Department of Health and Human Services Director. And those are only appealable to, quote, the Michigan Office of Administrative Hearings and Rules, end quote. It's according to the language of the emergency order itself. Article 8, Section 8 guarantees that institutions, programs, and services for disabled individuals will always be fostered and supported. That's what our state constitution guarantees for disabled individuals. But executive orders on masks have resulted in widespread denial of services for the disabled, also creating a pervasive impediment for the hearing impaired who read lips to communicate with literally everyone around them, not just the particular person to whom they are speaking at that exact moment in time. When I'm in the middle of a situation, I'm in a store, I'm at a party, it doesn't matter where I'm at. If I'm in a group setting and everybody has a mask on, I can't look around and determine who's even speaking to me, let alone if they are actually speaking to me, let alone with the words that they are saying. And that's not unique to me. I'm not the only hearing impaired lip reader in the state of Michigan. I'm just the most obnoxious to the Attorney General and the governor of the state of Michigan. So, likewise, these executive order restrictions have completely halted all in-person services for students with IEPs and 504 plans, not to mention the services and programs that are being denied to juveniles and adults being held in jails and detention facilities. They're being denied services because it's going to be safer for them if they don't have so many visitors coming in and out. Visitors for essential services, not to mention family members. And yet the same people, let's call it for what it is, the same liberals that are out there advocating for these executive orders as though they're going to be our saving grace from COVID-19, aren't these not the same individuals who are out there touting that people with disabilities and those who are disadvantaged are the ones that are most impacted by the criminal justice system? That people who don't have money, people of color, people who have disabilities are the ones who end up in jail because they're not white privileged men, right? Well, to a large degree, I would actually agree with that. So then why are we not making sure that those supports and services are maintained or even increased or enhanced for them at a time like this? But let us not forget our U.S. Constitution, our 10th Amendment, provides that the powers not delegated to the United States government are reserved for the states respectively or to the people. And reading that with our state constitution, Article 1, Section 23, that exclaims, quote, "The enumeration in this constitution of certain rights shall not be construed to deny or disparage others retained by the people," end quote. Why is that? Because we didn't get our rights from the government. We got our rights from God. So all citizens of the U.S. and the residents of Michigan, we are not limited to the liberties specifically carved out for us in the state and federal constitutions. We are given that plethora of rights directly from God, only some of which we have chosen to specify for constitutional protection, the remainder of which we still retain, however unenumerated they are. However, in stark contrast, the government, no government body or government official may act without having the express permission and authorization to do so. That permission must be found first in the Constitution, but then may end up even being limited by statutory provisions afterwards. So the long and short of it is, we have rights. We didn't get them from the government. The government cannot just take them away. Certainly, the governor, acting as a dictator of the state of Michigan, has no right to take away any of them, let alone each and every one of the rights that we have been given by God. And I'm going to have to count up exactly how many constitutional provisions that she has been violating by issuing these nonstop executive orders, but you better believe I'll have that number counted and ready on September 2nd when I go and argue in my 5 minutes in front of the Michigan Supreme Court that day. So what exactly does all of this mean? I'm arguing that all of it has to stop, and that there should be no need for the 1945 repeal or a 1976 repeal or any of it, because there's never any way, whether it's under public health code or whether it's under any one of these emergency powers statutes, no way should there ever be an order issued by a member of the executive branch that purports to regulate the people in any way, shape, or form. And even if it was something that was passed by the legislature, like Senate Bill 858, it doesn't matter, because those guys aren't allowed to violate our constitutional rights either. Hopefully the Supreme Court justices will hear that argument and issue a decision that goes along with those principles, that we have our constitutional rights that are given to us by God and simply enhanced or protected by the U.S. and Michigan constitutions. Hopefully that answers your question. How likely is it? I think it's extremely likely that at least 3 of the 7 are going to understand exactly what I'm talking about. And I think there's 1 or 2 that could very well come on board at that point. But, of course, I can make no guarantees. Okay, are there any other questions? Oh, if state constitution forbids interfering with contracts, can gyms who have paying members sue for contract interference? Absolutely. You should. In fact, I believe there's already a class action lawsuit, maybe not a class action, but a group of gym owners who are suing, I believe, the governor. I don't remember if that was in federal court or state. I think that was in federal court. Rachel, you crack me up. Well, thank you. I don't think I look this good for being this late, but apparently the lighting is, my husband turned up the lights so you can't quite see all the huge bags under my eyes and everything else, but I'll take the compliment. Thank you. Solitary confinement for extended care homes and Executive Order 148. I was already really emotional and excited about the fact that I was granted this oral argument time, and now you're going to ask me about something that's murder. I'm not sure I'm going to be able to address that in 5 minutes, quite honestly. How could I do justice to murder in 5 minutes? How could I explain to the court exactly how her actions are causing not only the death of the people who are in those nursing homes, but how they're having to die alone and sad, and unfortunately many of them are dying while being maltreated the entire time because, of course, there's no family or outside services allowed in to check on their well-being and care. That would take more than 5 minutes by itself. Yes, I do believe, Rich, that there's going to be a live stream. I think they have their own YouTube channel. I better sleep more than 2 hours on September 1st. Exactly. I am hopeful. I am hopeful. I want you to be hopeful. Kurt, I see your question about how do I think this will turn out in the end. I am hopeful that those Supreme Court justices will remember the oath that they took under Article 11, Section 1 of our state constitution to support and uphold the U.S. and Michigan constitutions. It doesn't say whether they like them. It doesn't say when it's not a time of emergency. It doesn't say when times are easy. It says to support those two constitutions, period. I'm hoping that those justices will take that oath very seriously and require the governor, the attorney general, and the director of the Department of Health and Human Services to do so as well. Absolutely. But we definitely need prayer. We need prayer on this. And I need your prayer that I only speak God's truth, that I don't put in there anything that's of my own desire or thought or whatever, that I'm doing it the right way, and that I'm representing the people, even unofficially, representing the people of the state of Michigan in a way that only God would want me to. How do I get the justices to not be biased? Maybe that's the ticket. Maybe the ticket is to find, in under 5 minutes, a way to address the very things that those justices are most caring about, most concerned about, the things that are special and dear to them, and relate that to the constitutionally protected rights that are being trampled all over right now. To get them to see from a personal perspective exactly what harm is being caused. And how easy, literally how easy it can be for them to say, enough is enough, this is over. The precedent that would be set from such a decision would be phenomenal. So start praying about it right now. Definitely. Did any of our constitutional rights come not only from God, but from essentially the people that were fighting for our rights? I would say our rights are given to us only by God. No one else gave us those rights. But I can tell you that every single person that fought and sacrificed and even died for those rights to get to the point of signing that Declaration of Independence and get to that point of signing the Constitution of the United States, they should be recognized, as should every single person that has fought and sacrificed in some way since that point in time to secure those blessings of liberty that were given to us by God. Will I be able to do justice to the recognition and respect that would be due to each of those individuals? Absolutely not. That would take far more than 5 minutes. My only hope is that I will be able to argue the points that need to be heard that day by those justices in such a way that it is undeniable what they need to do, and that they feel convicted to do the right thing and uphold each and every element of our state and United States constitutions, knocking down these emergency orders, these executive orders, and putting those unconstitutional acts by those government officials, putting them in their place. Hopefully, if I can do that, I will be able to pay the proper respect to those people who have fought and served and sacrificed, and some who have even died to secure those blessings of liberty that God gave us. So, did I answer everything? Okay. So, hey, 40 minutes, that's like nothing for me, right? Normally I can go up to 2 hours. Anyway, thank you so much for tuning in. I'm very excited. I hope you share in my excitement. It's only my exhaustion that keeps my voice down a little bit. But it is a very exciting time. And I want you to have hope. I have hope. God wants us all to keep the faith and to have hope. Have hope in each other and in all the work that we've been doing. Does this mean that between now and September 2nd, you guys should stop circulating the petitions or stop trying to educate your neighbors and friends and family members, or stop trying to kindly but firmly asserting your rights and educating business owners around the state who want to deny you services? No, don't stop doing a single one of those things. Absolutely not. I'm not going to stop. Every single day since the first week of April, every single day, I have worked on this on a variety of fronts, and I won't stop. My husband is exhausted. I'm exhausted. But working hard now, staying inside at a computer, typing and researching and doing everything else, and missing those very few precious hours of sunshine and heat that we get here in Michigan, that's a sacrifice I'm willing to make. Sacrificing the sleep that I need. It's a sacrifice I'm willing to make. Because we need to stick together. We need to stand up. We need to show them this is not acceptable. We need to show them that every single person here in Michigan, every single United States citizen, every single resident of Michigan has a right to know what's in the Constitution, what's in the law, be able to participate effectively in government at all levels, with all branches, should not be shut out from any of it. So if that's a message that resonates with you, I would ask you to not only sign the Restore Freedom Initiative Constitutional Amendment petition, I would ask you to circulate it. I would ask you to go outside of your comfort zone and get every single person that you can think of to possibly sign it. People you don't even know their names when you first go up to talk to them. Anybody that you see walking around in public without a mask, they're a good potential signer. If you play sports like we do for volleyball, the very first week I knew which people I had to ask. It's the teams we play against when we go under the net and we normally high five. The teams that just kind of go like that, okay, well, I'm not going to necessarily ask them. The teams that are willing to go ahead and give us that high five afterwards, because that is what we have always done, those are the people that I ask if they'll sign my constitutional amendment petition. Absolutely. So be a part of that freedom team. And it's okay if you're on the 1945 repeal team. It's okay if you're on the Recall Whitmer team. It's okay if you're fighting on a variety of other fronts. Or if this is the first time you've ever been involved in politics or anything whatsoever. That's okay too. But I'm asking you, please do not pass up this once-in-a-lifetime opportunity to be a part of something big, of something great. Are you going to be able to look back 5, 10, 20 years from now and say, I am proud of what I did back then in 2020. I am proud of the efforts that I put forth to secure our freedom here in Michigan or here in the U.S. The whole country is looking at what we're doing. The whole country. Everything in our country, in one way or another, is dependent upon how we succeed in our efforts here in Michigan. So please, give it your all. I know a lot of you, thousands of you, that have been volunteers with me since the very end of May or on into June, and circulating petitions or being a captain or being a driver or a distribution hub or a signing location. I appreciate everything that you do. I'm just asking for each of you, as well as those of you who haven't been involved yet, please don't give up. Please don't lose hope. This order that came from the court today, it's just a sign. It's a sign that things can happen. Miracles do happen. Things that are extraordinary and out of the realm of things that we're expecting. They can happen. I was able to secure 5 minutes of oral argument time in front of the Michigan Supreme Court on these very issues. Little old me, who am I? Go ahead, ask any of the state reps. They all know who I am. They're probably not going to tell you all kinds of wonderful things about me, unless they think it would be necessary to secure their spot in their general election come November. But I'm no more special than you are. I love my country. I love God. I love my family. I certainly love my children. And I'm willing to do anything to secure the freedom for my children that God gave them. Now is the time. We've never had an opportunity like this before. Everything is available to us in ways that have never been possible. Never in a million years did I think I would be given oral argument time in the year 2020 to argue against the governor's unconstitutional actions. And yet, in a matter of a couple of weeks, there I will be. Never in a million years did I think in the year 2020 I would be drafting a state constitutional amendment and trying to circulate it literally all across 83 counties of the state of Michigan to get 425,059 signatures. And yet, we are well on our way and have signatures in at least 82 counties, maybe that 83rd. I have to check with somebody from the UP. Do not lose hope. Do not lose your faith. God is here. He is with us. He wants us to succeed. But he needs us, his people, to stand up and fight. Fight in the right way. So to all of you who have continued to ask me questions about your children going to school or your employment within the school system or any other issue related to, basically being denied participation in some sort of good or service because you're not wearing a mask for one reason or the other, I don't have any Staples easy buttons for you. I don't have that quick answer. I'm working on it. And as much as everybody wants the Cliff Notes version, all of this, thousands of hours without even one day of rest in the whole mix, all of this is needed to get to that point. And hopefully one day I will be able to have an answer for you. But I could tell you this, breathing fresh air is a right guaranteed to us by God that our founding fathers thought was so essential, so fundamental to living, that they didn't even think they would have to enumerate it in a written document. Why would you need to put something like that in there? So thank you for paying attention this late at night yet again. And the document, the link to our website, the part of our website that has that document, that court order, I do believe is live and on our website, and it's in the description of this exact Facebook Live video. And the entire copy of the motion, the brief, and all of the exhibits that I filed is also available on our website on the Resources tab or Documents tab. And I'm not getting any confirmation either way from the handsome man over there. But, oh, and by the way, if you are in the Grand Rapids area and looking for a phenomenal meal at great prices, food that tastes great, it's healthy or not, depending on what you want, please do check out Florentine's on 28th and Ivan Rest. I think it might be technically Wyoming or Granville, but it's in the greater Grand Rapids area. Best food around. Absolutely. So make sure you check them out. All right, guys. Thanks so much. Have a great night.